Yes. 30. Yes, Mr. Parashar. Huh? What we have just thought about is this. We'll need to sign many orders today. Now, all those cases where there is an interim already, wherever there is an interim, we can have them listed on Tuesday or Wednesday, allowing the interim to continue for the next 2 or 3 days. Whether the CD is there or not, we'll just allow the interim to continue for 2 or 3 days, so that we, in case we grant a bail, we have the time to dictate the order and sign it, and they can have a copy today itself. What do you say? Interim for a day or two is not going to create any havoc, is it not? All right, you are mentioning item number 30. Huh? The CD is available. CD is available. List the matter again on when? March. Let's see. The Learned PP request for an accommodation to get the updated CD. Allowed. List the matter again on 10th of April. 22nd of April, interim to continue. Yes. 48. Next week. At the request of the Learned Counsel for the petitioner, list the matter again on the 1st of April. Yes. 37. The case diary is awaited. The petitioner is on interim bail. List again on 22nd of April. Interim continues. Yes. 47. When do you want it? At the 2 weeks. At the request of the Learned Counsel for the petitioner, with the consent of the counsel for the respondent, list the matter again on 21st of April. Yes. 41. Thus, the Learned Counsel for the petitioner for customs. For the customs submits that the CD is awaited. The petitioner is on interim bail, awaiting the CD. List the matter again on 20 April. Interim order continues. Yes. 35. Yes. The CD is awaited. Petitioner is on interim bail. Charge sheet submitted. The Learned Counsel, the Learned APP has submitted that the charge sheet has been submitted. The petitioner was earlier on interim bail. The interim bail is made absolute. Petitioner would be at liberty to appear before the petitioner shall appear before the trial court as and when summons are received. Yes, disposed of. 45. Yes. The TCR is awaited. List the matter again on 10th of April. 10th of April. Issue reminder for TCR. 25. The Learned Counsel for the petitioner has prayed for an accommodation today with the consent of the Learned Counsel for the NCB. Accordingly, list the matter again on, when do you want it? 2nd of April. Yes. The Learned Counsel for the petitioner has prayed for the liberty to withdraw this bail petition in its present form. Prayer is allowed. Bail petition is closed in its present form. 1-4. Yes. 1-4. Okay. 14 to decide. Yes. Yes. 26. The learned counsel for the petitioner has sought for an accommodation today. Learned APP does not object. Let's the matter again on 10th of April. Huh? 20? Item 26. Or 26 March. No, 10th of April goise. Item 26. 10th of April, yes. 42. The learned APP has submitted that the CD has not been received. The petitioner is an interim protection. List the matter again on 23rd. 23rd of April. Awaiting the CD. Interim protection continues. Yes? 29. You are for the informant, okay? Huh? When do you want it? The CD is here. Okay. The learned counsel for the petitioner has submitted with the consent of the learned counsel for the respondent number 2 that some out of court settlement is being arrived at, full stop. The learned APP has submitted that the case diary has been received, giving an opportunity of settlement. Now awaiting, on the submissions of the counsels for the petitioner number 1, a petitioner and the respondent number 2, list this matter again on 23rd of April. 23rd of April, the APP shall procure the up-to-date CD. Interim protection continues. Yes. 40. The learned APP has submitted that the CD has been received. When do you want it? Not, next week. Accordingly, list the matter again on 31st of March. Interim order passed earlier continues. Item 14. Yes. 46. Yes. Let the matter reach. We'll do it. Let the matter reach. We'll do something.
Delivery of judgment, item 1, criminal petition 590/2025.
We have allowed the petition without impeding any of your rights to file a fresh complaint. Yeah. No, it starts from your filing a fresh complaint. Yes. The protest petition which was taken up as a complaint in the absence of an affidavit and also in the absence of any prayer in the protest petition for taking it up as a complaint. On that ground, we have quashed it. But your right to file a fresh complaint would be there. You'll have the order by evening. We'll sign it after some time.
Delivery of order, item 52, 53, bail application 88/2026.
We have allowed the bill. We have allowed the bill, but you shall not in any way interact or communicate with the victim or the informant without the permission of the trial court.
For motion, here, item 1.
Yes. POCSO will give the notice to the respondent number 2. Huh? Okay, take down. What is the allegation? Why is the police constable? Oh. Notice has to go to the father of the victim. Huh? At page 10, the father of the victim is there. Then informant is the intention of the notification or the law is to protect the interest of the victim or the of the victim, is it not? So the informant is kept in that notification because it is usually the victim or the parent or someone who's interested in protection of the victim. A police constable coming and saying that, okay, I have recovered her, she has told me that she has got an affair with so and so person. So I'm lodging this FIR because the father was not there on the spot. Is it? Hmm? Notice has to go. Heard Mr. So and so learned counsel appearing for the petitioner, also heard the learned APP. The informant in the present case under section. No, this is a case for praying for regular bail in connection with session special case number so and so. Polton Bazaar PS case number recovered here in Gauhati. Okay. In Polton Bazaar PS case number so and so. Take from page 1, full stop. The informant in the case is a woman police constable. The FIR reveals that the father of the petitioner is identified with his address, full stop. Accordingly, petitioner to take steps for service of notice upon the father of the petitioner, father of the victim. Don't write petitioner at the top. Huh? Above also it will be victim. The FIR discloses that the father of the victim is identified along with his address. Accordingly, petitioner is to take steps upon the father of the victim in accordance with the prevalent notification. We'll stop. Call for the case diary. List again on, or call for the scanned copy of the TCR. List again on 8th of April, where you've given a scanned copy of TCR along with CD.
Step 2.
Okay. Item 47, make it 23rd.
Step 2.
Call for the case diary in connection with Tengakhat police station case number page 2. Huh? List again on 31, 2nd of April. Huh? Huh? Which vacation? 30 of March is before vacation. 2nd of April is before vacation. 2nd of April. The issue notice to the respondent number 2. Ah. What is your name? Nazamuddin and Samimuddin, huh? হ্যাঁ নিবেদনে যে বিগত খ্রিস্ট তারিখে বেলা 2 ঘটিকে আমার মেয়ে
খেলা দুর্ঘটনায় আমার মেয়ে সেকেন্ড সাইজ 15 বছর বয়স
বিবাদী
বিবাদী আমার বাড়িতে না থাকার সুযোগে আমার বাড়িতে আছে, আমার মেয়েকে কুষ্টিয়া থাকার সঙ্গে নিয়ে বাড়ির দক্ষিণ দিকে একটি নির্জন টিলায় নিয়ে যায়। সেখানে আমার মেয়ের সহিত বলপূর্বক শারীরিক সম্পর্ক করিতে থাকা অবস্থায় ঠিক সেই এই দিক দিয়ে আমার প্রতিবেশী জৈনিক নিজামউদ্দিন পিতা আব্দুল করিম এবং সামিম উদ্দিন পিতা শকুর আলী যাওয়ার সময় তাহাকে বিষয়টি দেখিতে পাইয়া বিবাদীকে বাধা দিয়া তাহাকে ধরিবার জন্য হওয়ার ঘুরিলে বিবাদী বুঝিতে পারিয়া দৌড়াইয়া পালাইয়া যায়। পালাইয়া যেতে আরম্ভ করিলে তাহার পিছনে পিছনে তাহাকে ধরার চেষ্টা করিতে থাকার সময় এই তাকে
There is no English translation. You are also going on a breakwise basis. Well, what is the mistake? No. Huh? Oh, forget it. Give us a story. Hang on. No issues. Yes, why these people are behind bars? Of? They were trying to take proof that this man has done something bad. Huh?
According to page 17, was ground of arrest it is stated.
Huh?
According to page 17, the ground of arrest of the premises of minor. She has committed something lordship that was captured as per forwarding report lordship that was captured by this two petitioner instead of lordship. How this lordship amendment of fact lordship. And lordship bail of the lordship rejection order that is on page 20 lordship will find lordship there is no objection on this petitioner from the informant side lordship. That is on page 22.
It was not that act which led her to commit suicide. It was your this act.
Amendment of suicide lordship. She has committed the mistake lordship. Because they have chased. As per FIR lordship, this petitioner has chased the court that culprit lordship.
We'll ask for the this thing. Just a minute, তাহাকে ধরিবার জন্য দাওয়া করলে এবারে বুঝতে পারে FIR does not say that any photographs have been taken or any arrest has been made. Call for the case diary short. Did we just want to know whether the photographs and video was taken? We'll see. If it is not there, you get your bill. No problem. If it is a allegation on the air, anyways, today we cannot. We'll note that. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. The allegations level in the FIR does not indicate any allegation of allegation which can be constituted to be offences under the POCSO Act against the petitioner's hearing. The allegation is that they had taken photographs while the minor was having an affair with one of the accused. Full stop. The minor has ended her life after the incident. Full stop. The learned counsel for the petitioner has submitted that there is no evidence of any photograph or video being made by the petitioners, and instead the FIR shows that the petitioners had tried to catch the assaulter, after which the minor victim had gone away to her home and ended her life. Full stop. Call for the case diary list again on. We'll see. You tell us. On the 6th of April 2026, since this court is of the view that the allegations of POCSO are not made out at this stage against the petitioners, notice is not being issued to the respondent number 2 at this stage. If we find something in the CD, we'll then issue notice. Huh? Ah, ah. Hmm. This is very good. Someone is standing on the road, you go with the electronic scale and start measuring what he has in his hands. That is how search is done in NDPS. Huh? Someone is standing on the road, you go with a scale, hold him, and then you say, we are weighing it. Okay, okay, contravenes this much. This kind of search is allowed. By any stretch of imagination, can you do that? Everybody will be at risk. Huh? Call for the case diary list again on the 31st, along with the FSL report. M6. Huh? Issue notice to the respondent number 2 in accordance with the prevalent notification. Call for the case diary in connection with Tejpur PS case number, page 1. Huh? List again on 7th of April. Given. Issue notice to the respondent number 2 in accordance with the prevalent notification. Call for the case diary. Case diary in connection with what notice? This is AB. Huh? BA. Without hearing the other side, can we make any decision today? Huh? To whom? That is to the arrest, but since it is a POXO case, can we do anything without notice to the informant? We'll take up this issue after the informant appears, or we appoint an amicus. But first the notice has to go. Yes? TCR may be called. Okay. What did we say? Issue notice to the respondent number 2 in accordance with the prevalent notification. Call for the scan copy of the TCR in connection with, you write this one from page 1. Page 1. I had marked in pencil. Okay. List again on 8th of April. 6th of April. 6th of April. Yes. Issue notice to the respondent number 2 and 3. 2 would do, huh? Item number 8. Soiful. So correct name is Soiful. Okay. Oh, what did you say? Issue notice to the respondent number 2 and 3 in accordance with the prevalent notification. Call for the scan copy of the TCR of pending in the court of Okay. List again on 2nd of April. Learned counsel for the petitioner has submitted that although the name of the petitioner is Muhammad Saiful Ali, alias Saiful Ali, you take from page 4. In the cause list, it has been reflected as Saidul Ali, alias Saidul Ali. That is at item number 8. Registry to verify from the records of the case and make necessary correction in the CIS according to the petition filed. Hmm. Just show me. Where? 16. What is the FIR? Just a minute. Officer in charge. This is 15/8/24. Independence Day celebration. He was who? Father is declared a wage war. Just only therefore broadcasted press release. Senior officer sabotaged, accompanied by commandant. Anti-sabotage. I was concealed in several layers. Purposely by the band outfit so and so. Somojyoti Loskar and Subhas Hira and Dipankar Gwala. Okay. Thereafter? Huh. 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 When was he arrested? Date? Huh? 21. Huh. 13th of June. In the month of June, he was arrested in connection with this Nagaon PS case number. Huh. Huh. Hmm. 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 What is his name? Where is Bhavesh Kolita's name here? In the FIR, it is not there. But he was shown arrested. Then 21. Oh, where is that? Where is his forwarding? 1/8. Huh? Just a minute. He was arrested in connection with PS case number 945. 344. Just, I understand. Just a minute. When was that bomb found in 2024? No, 15/8. 15/8 to the officer in charge FIR. That is 15/8. Page 16. Is it? 15/8. 15/8 the FIR was lost, 15/8 it was recovered. You are saying that in that period he was in custody because he had already been arrested in another case and he was released in November. Then how can he be connected with this case? Yes, madam, what do you say? When? Now when? 20 April. Huh? Elections will take away the right of liberty. 8th of April is a better date, huh? 8th of April. Call for the case diary. Or before that, you write, Learned Counsel for the petitioner has submitted that the petitioner had been taken into custody on 15/8/20. No, when? Earlier? On 13. Huh? On 13/6/2024 in connection with Tejpur PS case number 34/2024, and he was granted bail sometime in the month of November 2024. In the interim, he had remained in custody, in judicial custody, full stop. The present petition, which relates to the FIR number, or which relates to Nagaon PS case number 796 of 2024, emanated from an FIR which was lodged on 15/8/2024, that is during the time when the petitioner was in judicial custody. The petitioner has now been arrested in connection with Nagaon PS case number 796 of 2024 on the allegation that he was instrumental in planting improvised explosive devices on 15/8/2024 in the vicinity of Nagaon. Full stop. The learned counsel for the petitioner submits that the arrest cannot be sustained since it is an admitted position that the petitioner was in custody when the FIR had been lodged in Nagaon, and he could not have participated in any activity beyond the judicial custody. Full stop. The learned APP has sought for a short date to have her CD and her instructions. Accordingly, call for the CD and list the matter on 8th of April 2026. Yes. Hmm. Hmm. Hmm? Of the petitioner, the person who rented the vehicle, Vikas, huh? Hmm. Hmm. Yes, how soon the CD Chanmari? When? 30th. Call for the CD list again on the 30th of April. Hmm. Hmm. Where is the FIR? What is the allegation in the FIR? He is not giving back the money which he took for a land mutation. What is criminal about it? Huh? You never took the money. Huh? That is taking it a bit too far. You took the money, you better return the money and be safe. Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned APP. This is an application under section 482. You take from page 1. Huh? So-and-so. On going to the FIR, this court is of the opinion that the petitioner is required to appear before the investigating officer of the case to assist in the investigation, full stop. Accordingly, the petitioner shall appear before the investigating officer of the case on or before the 27th of March 2026. It is provided that in the interim, if the petitioner is arrested, he shall be released on bail on furnishing a bond of rupees 20,000 to the satisfaction of the investigating officer. Full stop. 20,000 with one surety of the like amount to the satisfaction of the investigating officer. Call for the case diary. List again on 20 April 2026. Yes. What does it say? Very bad man. Very bad man. Yes. Lawfully obtained. Was lawfully obtained by me for a period of so and so through tender process. One owner was falsely fabricated his signature. Has falsely fabricated his signature. Whose signature? No, he doesn't say my signature. He says his own signature he's forging. Huh? Where is the Assamese one? Oh, he's a settlement officer. No. Where is the Assamese version? জালিয়া কোনো এজন লোকে মোৰ স্বাক্ষৰ জালিয়াতি কৰি মোৰ নামত মিছা তথ্য পাতি তৈয়াৰ কৰি ইমান টকাত মই বিলখন উক্ত ইমানক বছৰ চলাবলৈ দিয়া বুলি অভিযোগ দৰ্শায়. Now, where is that agreement? You have the original of the agreement? Who has the original of the agreement? The petitioner has the original of the agreement? Huh? The petitioner has the original of the agreement with him. He has given it in the bail petition. He must have the original. You have signed it as certified true copy. From where? You have not seen it. Without seeing it, you have signed it. You have you have page number 21 to 23. You have the original copy with you. At present, no, but petitioner has it. Okay. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. The FIR, the statements in the FIR allege that the petitioner has forged the signature of the informant on an agreement to run a mean mahal. Full stop. The learned counsel for the petitioner has submitted that the petitioner will produce the original agreement before the investigating authority on or before the 27th of March to help the investigation proceed. Full stop. The IO may have the signatures on the agreement verified through forensic and a report be given to this court. Full stop. In the interim, it is provided if the petitioner is arrested, he shall be released on bail on furnishing a bond of rupees 20,000 with one surety of the like amounts to the satisfaction of the investigating officer. List the matter again on 29th of April 2026. Yes. Why? 20?
Sorry, no, the accused by responding to court. The submission charge sheet appears and applies for previous case. The previous bail is granted on a condition that he shall not leave the jurisdiction of the court without prior leave of the court. And the court is very clear that if there is a violation of this condition, the bail will be cancelled.
Seen.
The accused, respondent number 2, saying that he resides in Uttar Pradesh, he is working here in the bank, so
Mm.
it is not possible for him to come from Uttar Pradesh.
Every time.
So,
Mm.
yeah.
Yes.
If you will start showing
28-1-2026. Accused is present. So now he says he prays before the court that allow me to go and attend my office there. Huh?
because I am staying in Uttar Pradesh, working in Uttar Pradesh.
True.
Not there.
Huh? Which condition? He is taking the permission of the court to leave for a certain period. Yes. Yes. Huh?
That from 6/2025 till 2026, he was staying in the
Tell us from when was he not available in the jurisdiction of the court? From which date to which date he was not available in the jurisdiction of the court? Tell us for the date from which he was not available within the jurisdiction. You have come for cancellation of bail, sir. Mm.
The order said that he is already working there in the bank money.
At the time of the alleged cause of action, he was posted at Nagaon and is presently posted in the state of Uttar Pradesh. When? Huh? What was the allegation against him? Huh? Workplace. At workplace. At workplace. At workplace. He'll face the disciplinary proceedings. He's facing a criminal proceedings. Anywhere. Anywhere. Workplace is a workplace. Wherever. Who says a private place is not a workplace? If a government servant harasses a lady anywhere she is working, it's a workplace. The protection is at any workplace. Otherwise, companies would never be safe. That will go on. He is facing a criminal proceeding here. Why do you want him behind bars? Is it not vengeful? Trying to put him behind bars now during trial. You got a one small handle and you are trying to put a person behind bars, take away his job, everything. No, get him convicted. Concentrate on getting him convicted. Yes, we'll issue notice to him. Issue notice to the respondent number 2. Full stop. And I heard Mr. So-and-so learned counsel appearing for the petitioner also heard the learned APP. Issue notice to the respondent number 2. The learned the learned counsel for the petitioner has submitted that although the order passed on 6/6/2025 had directed that the petitioner should not leave the jurisdiction of the court without prior permission of the court, and he shall remain regularly present on all dates as is fixed in the case, comma, the order dated 28/1/2026 reflects that the petitioner is that the accused respondent number 2 is now posted at Punjab National at where in the state of Uttar Pradesh, and therefore he has sought liberty from the court to attend office at Uttar Pradesh. Full stop. According to the learned counsel for the petitioner. Whatever. According to the learned counsel for the petitioner, the accused respondent number 2, having left the territory of jurisdiction of the trial court without permission, comma, the bail is liable to be cancelled. Full stop. Petitioner to take steps for service of notice upon the respondent number 2 within a period of 7 days from today. List again on, we'll have it on 4th of May, giving a month, on the 4th of May 2026.
Supplementary code list, item 54.
Yes. PP is shown in the list, cause list. Where is that last order? Last order to put. Additional PP again not shown. They have supplied. Any? What to do today? Yes. Which hunting? A B. We call for the case diary. How? Have you seen the allegations? Have you seen the allegation? Have you seen the intent of the law not to go for? Huh? Who? No, no, no. You were a group. You were a group. You were a group. That is what the law tries to stop. Whom? Maybe you were all present there. Were you not? Anybody tried to say? Anybody tried to say? Then nothing doing. Nothing doing. That is the icing on the cake, but the cake is there. So with the presence of the cake, it is still diabetic. Is it not? Call for the case diary. List again on 8th of April. 7th. It is seen that despite the order given on the last occasion, comma, the cause list does not reflect the name of the additional PP. Full stop. Registry to look into. What did I say? To show as PP Assam. Registry to look into the order and the cause list and make necessary corrections. Yes. Next to Matok.
Yeah, item 24.
Nurchan. Yes. Yes. From 2024, this is pending. That it has to be before this bench. No problem. Tell us. What? After some time? Or you want to do it? Why don't you do it? After some time, PP record to deliver.
27.
Why? Why? Why not now? Huh? NDPS.
28 May reserve. This is the case, Lordship. The regular bail, Lordship. Petitioner is there the 34, 78 days, Lordship. The petitioner is 19 years, the victim is 17 years for month.
And for whatever reasons, notice has not been issued to the respondent number 2. Why? No, notice has not been issued. Notice has not been issued. Forget the step. I did not direct for issuance of notice. You did not point it out. First order says list the matter again on allowing CD. 55 days in custody. What is the FIR?
Whether it's filed within time or not. Because as per the law, from the last day, we have submitted one 96 ENS lawsuit. The statute has to be filed, the investigation has to be completed within 60 days.
The allegation is of rape. POCSO. 197. What do you say? 60 days? Just check. Just check. If it is default bail, nothing can stop him. Notice or no notice. Perhaps that is why no notice. Perhaps that is why no notice. Next to you.
Supplementary clause list item 56 to 59.
Yes, sir, that series. Yesterday series. Ah. Yes, who is this man? Azizul Haq. What is the allegation against Azizul, madam? Huh? Therefore, when he's not there in the FIR, but others have implicated him, his presence we have to assume. Tell us. That is luck. It could have been grievous. It is simple as luck. There is no allegation of hurt, grievous hurt or hurt. It is not there. No, the allegation is only of deterring or where is that? Where are those sections? Forwarding is at page 17. Is this only of deterring the government serving? What is 127.2? Okay. What is this arms act coming from? Where is this arms act coming from? Arms act? Gun. So attempt of arms act. It is not arms act, it is attempt of arms act. Wrongful confinement. 121. What is 121?
Another one is 132. That's all, but the publisher deciding the duty, they extend 2 years more time also. And another one is just 140 days. Collective arms with intention of waging war against the government of India. But silence
Doesn't come in. Yes. Food. We are not. Yes. How many days? Length of detention in such cases is not a consideration before this court. Uniform. The only problem is, had it been neighbor, someone strikes, different. Once you see the khaki, once you see the white apron, once you see the black coat, and once you see the camouflage uniform, you are supposed to be restrained. You should restrain yourself. You cannot go and attack police, no.
That happened caused by the police.
Who will do it? We'll ask the CBI to do it. Then don't see, Mr. Khan. We have accommodated the person against whom there is no sentence. We have accommodated him yesterday after court hours, almost after court hours. Have we not? Mm. Then if he is not named in the FIR yet, his name has come up in the statements. He was there. Not necessary. You have already beaten me up. Why should I want more remand? Not this one. What is the next? Only because the uniform. Otherwise, 51 days was good enough. This one, this Shahidul, there are implications. Shahidul, in Shahidul case, females are also implicated. Oof, yes. Hmm. Police has named Alima. Mufida. Mufida is Zahir. Mufida is. Oh, no, no. Okay, hopefully 10 more days only. That is all we can say. If the charge sheet doesn't come in 60 days, you would have a default. But police uniform attacking, we are not. Hmm. Okay, we'll send it along with it, no problem. Yes, yes, 27th. You want it on 27th. You want these cases on 27th. I'm not inclined since the uniform is involved. I'm not inclined. Mere petty fights, no problem. 684, yes. Azizul. 684 is, huh, huh. Huh. In this case also. Huh? Heard Mr. M. Khan learned counsel paying for the petition, also heard Ms. Swinson learned APB, full stop. So what do you do with Azizul? Reject him. If we take it up, you have to say something about Azizul also. If we say that Jahidul, there is nothing against him and therefore we are granting him the bail absolute, right? We have to also say that there is something against Azizul. Moment we say that, better you withdraw for Azizul, move for press for Jahidul. 27 get it listed Azizul along with those. And that is what. But what do we say about Azizul in the same case? Can we grant a bill for one person and get it listed for the other person before some other court? Uh, uh, okay. Kilkhile? Heard Mr. M. Khan Learned Counsel appearing for the petitioner, also heard the Learned APP. The Learned Counsel for the petitioner has submitted that the petitioner number 2 has been granted bail in connection with AB number so and so 698 of 20 or BA number 698 of 2026. Huh. The Learned Counsel has submitted that the FIR involved in that case, in the FIR involved in this case, are correlated as they arise out of the same series of incidents. Full stop. Accordingly, he has prayed for grant of bail to the petitioner number 2 at this stage. Full stop. Accordingly, this court has gone through the case diary This court has perused the case diary and is of the opinion that the petition number 2 can be granted an interim bail at this stage. To the petitioner, the petition number 2 can be granted an interim bail at this stage. Full stop. Accordingly, the petition number 2 shall be released on bail on furnishing a bond of rupees 20,000 with 2 sureties of the like amount, subject to the satisfaction of the CJM Bongaigaon in connection with Bongaigaon PS case number 14 of 2026, registered under Silo, page number 1, full stop. The bail, the prayer for bail to the respondent number 1 shall be considered on 27th of March. Full stop. List this case again on 27th of March. Igita kesoto didiok. Baki kita jikita connected matter kita ase. List along with BA number 684 of 2026 on 27th of March. Along with BA number, what is the other BA number on 27th? Or AB number? AB number 20, huh? It was 27th of March, which disposal nai kintu ekita. Eto logoto dibo.
Daily BA item 31. Daily BA item 31.
31. CD, CD is awaited. Petitioner is on interim. List again on? Tell us it. 23rd of April. Interim to continue. 32. 32 no CD. Huh? 32. CD is awaited. Petitioner is on interim protection. List again on 23rd of April 2026. Yeah. 33 interim, 33 CD is there. Yes. Yes. Ereka nuts. Yes. Huh? Custodial interrogation not necessary. Custodial interrogation is not necessary. He'll not keep appearing. The learned counsel for the petitioner, Mr. N.J. Dotto, has submitted. The counsel for the petitioner, Mr. N.J. Dotto, has submitted that the petitioner has appeared before the investigating authority as and when called for. Full stop. The learned PP has submitted that the bail bond is available on records, although the statements are not there. In that view of the matter, this court is of the opinion that the custodial interrogation of the petitioner would not be required at this stage of the investigation. Therefore, the interim protection granted to the petitioner on 8/1/2026 is hereby made absolute. Petitioner shall appear before the trial court as and when summons are received. If, as and when summons are received. Yes. Okay. Okay. In item number 24 and 43, you see, at the so 43. Okay. At the request of the learned counsel for the petitioner, list the matter again on Tuesday. Duita connected matter no hoy kintu. Separate matters hoy. Duita belek belek order dibo. List the matter again on 27th of March. Full stop. The CD is available in item number 43. 43 likhibo okol. CD is available and be retained. CD is available and be retained. Yes. 34. What has happened? Oh, that after a long time he was sought to be arrested. Some shooting had taken place for a tea state and now they are trying to arrest him. Yes, tell us. Notice to whom? This meant this is a case where there was an incident somewhere in the year 2012. In 2012, he was there in the camp, not arrested. Now they are trying to look after him to file an additional charge sheet. No, what do you call it? A supplementary charge sheet. To show that he should be in custody. Yes. Huh. The tick mark. Have you read the line below there? Witnesses referring to him. Have you read that? What does it say? Nothing. Then, so we are making it absolute. Huh? He has appeared before you. That he's saying he's appeared. The learned counsel for the petitioner has submitted that the petitioner has appeared before the Sutia police station and before the investigating authority in the Sutia police station and also before the CID officials in connection with the case, with this case, in pursuant to the privilege of interim bail granted to him. Full stop. The learned APP has produced the, what is this? The CD. The CD. Full stop. Upon going through the same, this court is of the opinion that the petition, that the custodial interrogation of the petitioner at this stage may not be necessary. Full stop. Accordingly, the interim protection granted on 19/2/2026 to the petitioner is made absolute. However, the petitioner shall appear before the investigating authority and or the trial court as and when called for. Stop. AB disposed of.
Finding item 28.
Huh. 22 days. The CD part is done. Huh? Even if it is 22, still it is within 60 days. Huh? Just a minute. The issue is not one of what is that common term used? Romeo Juliet. This is not Romeo Juliet. This is Beauty and the Beast. So we'll have to issue notice to the respondent number 2 in accordance with the prevalent notification. The scan copy of the TCR call for has been received. Stop. Earlier notice was not issued since there was no, since it appeared that the charge sheet had not been submitted within the statutory period. Full stop. However, it is seen that the charge sheet has been submitted within the statutory period. Full stop. List again on. We will say 10th of April. 10th of April. Petitioner to take steps upon the respondent number 2 within a period of 2 days, or within Tuesday. Tuesday, what's the tarikh? 24th of March. We have issued notice to the respondent number 2. Do you? Huh? No, 10th April. Our steps lobo by 24 March.
Finding item 27.
Yes, sir. This is 27. 27, 25, huh? You were in the truck. You were inside the truck. You are the helper. What had happened? Page? Hmm. One six. Blue color vehicle coming from Mizoram. When their Soptogram Suzuki Brisa coming to us. Set location, occupants, village, questioning disclosed. You were inside the vehicle. You were inside the vehicle? Ah, yes. Then what is your ground? Not served.
One,
32. Why this ground was not taken before the remand court? Yes, what is this? Hmm? You have a child of 2 years. Okay. Okay. Both father and mother inside. Husband and wife. You take the risk, you suffer it. Why both traveling in the same car with such items? Hmm? Why? Read it. Read it. 480 years. He's applying 480 along with 47, 48. Now he's going 10 times. 48, 10 times, 480. Tell us. Hmm.
provided that court may direct that a person requesting for Gurdwara or close to be released on bail.
Hmm.
If such by or is a woman or is a sick
Hmm.
or in perhaps lordship for
Provided where? Clause 1. Hmm. If she's a woman, we can release her. Eh? Hmm. What about 47, 48? Hmm. So proof of service is not there. And so now when we are saying only the women, by stopping that by 37, you have given it to both of them because of 48. Before the remand court. Why not before the remand court? Educate them also. Educate the councils appearing in the what did it say?
decided
Saying what? It has been sent. Bura. প্লেটখনৰ সেইটো দিবলৈ কওকচোন ডিঙি সেইটো where was it taken 48. Both the accused person acknowledge the same. Further, the intimation under so-and-so was also given to the accused. But there is one order from this court saying that the current situation of Manipur 48 cannot be served. Huh? Another case it was there where 48 was rejected in case of Manipur. Yes. There is one case where we have rejected. Yes, we'll allow this. We are not on 47. We'll only quote 48. We'll just say that emails were sent, but there is nothing to show on record that the notices had been received by any family, friend, or relative, and therefore, Anna, heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. Full stop. The learned counsel for the petitioner has submitted that the where is that arrest memo? You are saying it is not done properly. What about the arrest memo? Does it contain the signature of any independent witness? It's not there, no? Has submitted that the arrest memo does not contain the signature of any independent witness, and further, no notice and as required under section 48 of the BNSS was served upon any family, relative, or friend of the petitioners after they were taken into custody. Full stop. The learned counsel for the petitioner submitted that since the statutory provisions relating to arrest, which would have entitled the petitioner a full opportunity to defend himself at the time of prayer for remand by the arresting authority, had been violated when none of the relative friend or family of the petitioner had been informed about the arrest. Full stop. The learned counsel for the petitioner submitted in view of the violations of the provisions of Article 21 and 22(1) of the Constitution of India, the petitioners would be entitled to be granted bail since their custody after the violation has to be held to be unconstitutional. Full stop. The learned APP, who has gone through the trial court records, has submitted that there are enough evidence to show that communication had been sent to the concerned police station having territorial jurisdiction over the residential area of the petitioner. However, uh, it is noticed that there is no reply or proof of delivery of the notices under section 48 on any family, relative, or friend of the petitioner. Full stop. The learned APP has also submitted that uh, the TCR does not reveal that the memo of arrest contain the signature of an independent witness. Full stop. The learned APP has, however, submitted that since the amount recovered, since the quantity recovered from the petitioner is of commercial quantity, therefore the rigors of section 37 would apply. Full stop. This court has gone through the trial court records and also through the records which are annexed to the bail petition, and it has been seen that the notice under section 48 does not appear to have been served upon any family, friend, or relative nominated by the petitioner. Full stop. In such circumstances, this court cannot overlook the assertion of the petitioner that the fundamental right of the petitioners under Article 22(1) of the Constitution of India has been violated. When the fundamental rights are violated, the rigors of section 37 of the NDPS Act would not act to impede the grant of bail to the petitioners, full stop. In view of the aforesaid, this court is of the opinion that the petitioners are entitled to the grant of privilege of bail in connection with Dholai PS case number 98 of 2025, corresponding to GR number 1260 of 2025, pending in the court of, which has resulted in NDPS case number 83 of 2025 before the court of the Special Judge Kachar Silchar. Full stop. The petitioners have declared themselves to be residents of an area which is beyond the territorial jurisdiction of the trial court. Full stop. In such circumstances, a hey to didibo. Eto kuntu case asle janane? Pamidi Anand boli eta ase. Tapra didibo. Khali duitai to husband and wife too. Abo. Ei duitate each ke dibo lebo respectively ke dibo lebo. We have allowed it. Be disposed of. Kona. No.
56.
AB. The learned APP has submitted that charge sheet has been submitted by CS number. The petitioner was on interim bail. Same, it is made absolute. Petitioner shall appear before the trial court if, as and when summons are received.
48.
The learned counsel for the petition, the learned APP has submitted that the charge sheet has been submitted. Learned counsel, wide CS number. Learned counsel for the petitioner seeks to withdraw this bill or to withdraw this petition. Instead, prayer allowed. AP closed. This is a matter where we had asked where the wife was behind bars, the husband was on the run, some recovery was made from the house. The husband, after we passed an order, the husband surrendered. Now both husband and wife are in custody, children are outside, and this is an AB for the husband, which was pending. But he surrendered because he thought that the wife will get the bail in the meantime.
59.
Yes. No interim. He is not on interim. When? Not from today. It was already, you sought for it earlier also, huh? Oh, where you tried to kill the police officers by tractor. If the police officer's name is not Rajnikant, we are surprised how he escaped. Chastened by a tractor throughout the village. List again on 7th of April, awaiting the case diary.
44.
Still, yes. Dismiss it. Why? Why not? He's behind the bars. He will not be able to take steps. You have to take the steps. The office note reflects that the steps have not been received by the registry petitioner to verify and take appropriate steps. List again on 7th of April. then the investigation will stop. PP at liberty to call for the updated CD. Ask them if they want it back and updated. On 4th, 7th, 7th of April.
Item 14.
I will point out something. Let me place first, then I will reply.
Regarding the
According to the order, that I have deposited 20% of the stake amount, but because of that, we have filed this extra, I must deposited the amount. But in fact, some was that, document I see that order, page, order is 31 cents.
what does it say? Willing to deposit. No. Hmm. Hmm.
Deposited by the deposited by the applicant to the respondent for operation of steel order has been taken up for claim. That copy of the order will form the part of this. So that order is there, your lordship will see that the select court as a potential issues that 20% will be considered applicant.
Where? Where is that? Para 5 is wrong. Para 5 is a wrong recording. Is it a wrong recording? We are asking you that. Simply tell us that the court has wrongly recorded your submission. That is what you are saying.
Willing to settle, still he is willing to settle. And even if your lordship direct to pay, he will pay. That is not a, that I will not have submitted that he has already paid. So he is willing to pay. And the chair is willing to pay. And this is a register only 20% of the compensation before the trial court. So, in para 5. And thereafter, my lord, on this belief, my lord, we filed a petition before the trial on 27th of December. And the case paper was put up on 57 people and on 30 on 8.
Tell us one thing. Operation of the impugned order was already stayed by the order dated 14/11/2022. Is it? Now the appeal is gone. The criminal appeal has been dismissed. Why don't you move an appropriate application for modification of the order dated 31/10/2023? Why are we discussing it on an affidavit? True. So what will be the result of it? To do what? Is it so moto? You move an you move an application for modification of that stay order.
We are not we are saying that he has informed the court that he has already deposited that 20% in the trial court. Trial court means before the sitting court, district court. So on that belief, we filed a petition there. And the trial court, the court says that no such payment has been made. So he has made a false statement.
When did you receive the affidavit? When did you file it, sir? No, there is no such affidavit on record. There is no affidavit on record. Copy, sir, but there is no affidavit. Video record. We'll take it up after 5 minutes, go through the record. I have not formed that affidavit. Yes, yes. What is the item now going on? No, what is the item now? 40. Did you? Sao pai hoto, time ase. Item 50, he wants to see the record. Time ase.
Item 15 to 17.
Yes, sir.
Proceedings drawn up against the petitioner under section 158 of the Prohibitions, primarily on the ground that the petitioner was neither a signatory to the checks in question, or he was in charge of the affairs of the association. So therefore, the case disputed against him in the government court below is not maintained.
Anybody appears? Tell us.
In this case, committed by a judicial process.
Mm.
From purpose. It is the treasurer of the association,
Present.
present treasurer. Executive there no.
Signed it.
Under section 141, so 141 will come into because when a offense is committed by company, which also includes association of persons, then the persons who are responsible and in charge of the affairs of the company at the time of commission of the offense, he will be liable. And this check
Was issued on
was issued on 8/8/2019.
8/8/2019. Okay.
Check default 21/10/19.
8/8/19 21.
21/10/2019.
हाँ ठीक है.
Person, the earlier treasurer, as per their own admission, he died on 10/3/2009.
But check was issued on 16/8. The treasurer whose signature you are showing died in 10/3. So he signed it after. No. Who? When did he die? You said 16/8. Anyway, someone who was there as the treasurer in the month of March signed a post-dated check, and that post-dated after signing the post-dated check, it bounced, and the person had already expired by the time when he had when the check had bounced. Thereafter, what happened? Hmm. 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 Till the notice is served and not paid. Hmm. Hmm.
He was the treasurer, the commission of the office.
Hmm.
And he was in charge of and responsible for the affairs of this association.
Hmm.
And as per the certain guidelines, in such cases, what is to be pleaded in the company? He had to plead that the accused, that is the petitioner, he was in charge of and responsible for the affairs of the association. That has to be treated specifically. That much is necessary, my lord. Now, whether those pleadings are true or false, that will be decided
In the-
trial. So, in our complaint petition, specific pleadings are already there. Now, apex court has also made a distinction. Because when the judgments were passed, my lord, various usually these were discussed in the light of directors, managing directors, non-executive directors. So apex court has made a clear distinction that in respect of those some specific posts, like managing director, the name itself is suggests that he is
Manager.
he is the manager, he is managing the affairs. In case of those specific posts, even those pleadings are not necessary. Here he is a treasurer. Treasurer, so he is, by virtue of this post, he manages the affairs of financial affairs of the association. He is the one who has to clear the check. Now here, the check did not bounce because of insufficient of funds. They have stopped the payment. And now they are saying that he was not in charge. In their petition, it was not their case that he was not in charge of or responsible. Their only ground is that he was not a signature. Now, even a non-signatory, by virtue of 141, my lord, he will be liable. Now, here I would like to lay an apex court judgment. See the full bench judgment. SSC page number 89, SMS Pharmaceuticals Limited. But here, the division bench has referred this
2005. 15. You have given me 2015. এইখিনি কি হয় গুচাব বেয়া দেখি 2005. Just a minute. What does it say?
Three questions were formulated. Matter arises from a reference to the bench of this court for determination of the following questions by a larger level. First, my lord, whether for purposes of section 141 Negotiable Instruments Act 1581, it is sufficient if the substance of the allegation read as a whole fulfill the requirements of the said section, and it is not necessary.
We read it.
Whether a direct charge of and responsible to the company for the conduct of the business of the company, and therefore be the business of the company.
Yes.
Even if it is held that specific governments are necessary, whether in the absence of such government, the signatory of the check and or the managing directors of joint managing director who admittedly would be in charge of the company and responsible to the company for conduct of businesses to the state. The findings. There are the last.
Yes, done. Read.
Our that in our complaint, you have specifically stated that it's respondent number 2, respondent number 3, the instant petitioner, he was in charge of this financial affairs of this association, and 2 and 3 have directors of bank to stop the payment. Page 18. Our complaint is next. I'm going to line from the top. What are the there are 16 last question. What are the accused number 3? Being in charge of the post of treasurer.
Where is it? Just further the accused number.
Being in charge of And being the authorized signatory of the accused number one in respect of its account is responsible for not honoring the check and for not making payment of the check amount after receiving the notice. It is liable to be prosecuted and punished under section 138, paired with section 141 of the Negotiable Instrument Act.
Yes, sir. What do you say?
Yes. Neither form that has been, then from a petition.
Mm.
2005, pages, which was subsequently discussed by the apex court in 2010, 11 SCC,
Mm.
page 203.
What does it say?
At paragraph 15, apex court has said, we have carefully considered the submissions made on behalf of the respective parties, and we are unable to persuade ourselves to differ with the judgment and order of the High Court. The judgment in SMS Pharmaceuticals significant case, which was relied upon by the High Court while interpreting the provisions of subsection 1 of section 141 of the 1881 Act, made it very clear that unless a specific government
Which is the paragraph? What are you? Of what? Of?
Back B.
Para 15.
Yeah.
The apex court in Ramesh G. That one.
No, para B,
Oh, we went one judgment ahead.
1000
Ah,
internal state equal 6 at paragraph 15.
Hmm.
First, made it clear that unless a specific development was made in the complaint, that at the time when the offense was committed, the accused person was in charge of and responsible for the conduct of the business of the company, the requirements of section 141 must be satisfied. And Lordship will now see the evidence on affidavit filed on behalf of the petitioner in the learned court building.
just a minute. Yes, what are you saying?
The person, the accused person should be in charge of was in charge of and responsible for the conduct of the business of the company.
That is what we were trying to understand. Some treasurer at some point of time signed a check because the money was available in the bank. Huh? Later on, the managers of this thing, of the organization, the managing persons in the organization, they do things which lead to the bouncing of the check. How is the treasurer responsible, the present treasurer? How can the
Treasurer
He's an employee. He's an employee. No, treasurer is never a decision making order. By what stretch of imagination? Huh? He signs the checks.
Fine.
He is told that, look, sir, we company, we are paying this, please pay it. He verifies whether it is from the concerned authority and he says, okay, pay it. He has to keep that accounts. He has to know what is happening. He does not decide payment. He simply signs it. Treasurer is never. These who the treasurer said don't pay. Who said who told the bank don't pay? Association. How can the treasurer be liable?
Here, my lord.
You have to show, see, if you want this judgment to be applicable, SMS Pharmaceuticals, do you have the judgment that he was reading? 2010 judgment. Central Bank Asian Global. Have you read that? Let me tell you one sentence of it. Why we are putting this question to you. This question has come up because of paragraph 9. If a person committing an offense under section 138 is a company, every person who at the time of the offense was committed was in charge of and was responsible to the company shall be deemed guilty of the offense. It was urged that the High Court had wrongly interpreted the provisions of so and so and so and so. Then it says, the persons who are managing the affairs. A treasurer is not a manager is not a person managing the affairs of the company. He is a person who is executing the decision of the managers of the company. Even if we take this to be a company as such, a juristic person, an artificial person, he is not the person who takes the decision. He is the person who executes it by signing the check. Without his signature, money doesn't go out. One common man for all the whole company. Whatever needs to be signed, he has to sign it. That is the only authority of a treasurer. He has to know what has come in. He has to know what has gone out. Anybody asks him, he has to give the full accounts. Please.
The person committing an offense under section 130 with the company,
Mm.
the person at the time the offense was committed was in charge of and was responsible to the company for the conduct of the business of the.
Now let us stop here for a moment. Every person who was in charge of the conduct of the business of the company, or every person who was responsible to the company for the conduct of the business. It has to be either of the two. Can the treasurer say we should pay this money? No. Can the treasurer say we should not pay this money? No. The decision comes from the executive body, general body, whatever it is, managing committee, whatever it is. And the treasurer says, yes, we have the money to pay, or we don't have the money to pay right now. But the decision to pay or not to pay is never with the treasurer.
Now, here, my lord, only, at this point, my lord, it's to be said whether
For you to proceed, once that issue is raised here, for you, allowing you to proceed there, prima facie you have to satisfy us that a treasurer is a person who is responsible to the company or is in charge of conduct of business of the company to bring in it is registered. It's a society registered, is it? That is what we are not convinced with. Anyway, not today. You can take this back. Heard the learned counsel appearing for the petitioner and the respondent. Full stop. এখনো দি দিয়ক এই দুখন দি দিয়ক admit list again on yes PK hearing date after the bihu or 9th of April 9th of April pre-bihu 9th of April in the hearing list. Oh, it's made of blue here, so 7th of April. Nalaga 7th of April nidibo. 21st of April. Interim order passed earlier continues. But you have to address on that a treasurer is a person who is in charge or is responsible for conduct of business. Mm.
And as per my lord, the last order passed up.
Mm.
25.
Mm.
They have complied with the directions as given in this order. And accordingly, we have deposited a sum of rupees 1,50,000
Okay.
as required. And today I have brought the receipt also as given by the.
File it in the registry. File a copy of it in the registry. Have you filed it?
I find that the registry.
No. Put a copy to you.
Draft payment was made, the draft is dated 0409/2025.
Did you come where did you? As required by the order dated 31/7/2025, the
Now, as per deposit, so the execution of the remaining part of the certain past against the revision petition shall remain suspended till disposal of the criminal revision petition subject to the payment. So when I have paid the payment, I shall require to. So order suspension date can be. And I have taken this step on the respondent number 2.
item 18. This is item 18. Okay, item. None appears for the respondent on call, Mr. A.K. Jain. The counsel for the petitioner has submitted that in accordance with the order dated 31/7/2025, the necessary payment has been made, and he has also submitted proof of such deposit before the learned trial court. You made the deposit before the trial court. Where did you deposit the money? Before the registry of this court. Full stop. He accordingly prays that the further execution of the remaining part of the sentence and maybe suspended. Full stop. Since the order is at 31/7/2025 has been complied by the petitioner, the execution of the remaining part of the sentence passed against the revision petitioner shall remain stayed till disposal of this criminal revision petition. full stop. And, although wakalatnama has been filed for the respondent number 2, comma, none appears today, full stop. None appears today, full stop. List again on 30 April 2026, allowing the respondent number 2 to put in appearance. এই উকিল দুজনৰ নম্বৰটো যে ইয়াত আছে চাগে। Just a minute. এইকেইটা এই নম্বৰ দুটা যে এই নম্বৰ দুটা এই ফোন নম্বৰ কেইটা নোট কৰি দিবচোন। Yes, sir. Oh. Hmm. Hmm. $90? Oh, just a minute. What is this? What is this IA for? Oh. Hmm. This IA 1123 of 2025. Yes, Mr. Sharma. Yes. 28/1/2026. Have you seen the order in the IA? Kindly go through the order. Kindly go through the order. Huh? IA is listed. We'll take it up after some time, 5-10 minutes. Please kindly go through the orders on the IA. There are specific orders requiring you to make payments. There will be violation of the orders of the court. You go through the records. We're giving you the record. IA con DDO. IA copy to DDO plus silo. This is item 20.
May it please, Your Lordship. Lordship, am I audible?
Yes. And visible.
Lordship.
Yes.
Lordship, this quashing has been filed for quashing of the FIR dated 5/8/2020 that has been registered as Kitanagar PS case number 226 of 2020 under section 498A and 325.
Yes.
Now, Your Lordship, all these past 5 years, there was no whisper, and I have not received any summon from the Honorable Court below. Now, subsequently, I have been selected as a junior assistant at the Pragjyotis College. As per the notification dated 18/8/2025, and subsequently, when the police verification came, I could come to know that my police verification has been stopped because of the pendency of this particular FIR, Your Lordship.
Okay. How are you related to the FIR?
I am the husband, Your Lordship. The FIR was
You don't
lodged
know
by
that
the
the
wife.
FIR had been lodged.
FIR has been lodged against me on 5/8/2020. And that apart, Your Lordship, on 39/2022, I have been granted a divorce decree by the Honorable Family Court Principal Judge, Your
Does
Lordship.
that absolve you of the allegations of 498A which you had committed prior to the divorce? It does not absolve you.
No, no, Your Lordship.
So that will not be of any help. Okay, we skip those pages. What next? What do you want? Quashing of that FIR?
Quashing of the FIR, because
Why?
till date, Lordship, because that particular issue is
Anybody
hampering my...
appears for the respondent number 2? You are appearing. Divorced man now, you have divorced him, let him go. Huh? If the FIR is quashed. Yes, happy.
Lordship.
Huh? Heard Mr. So-and-so learned counsel appearing for the petitioner and also heard Mr. So-and-so learned counsel appearing for the respondent number 2 who appears on receipt of notice. Ms. So-and-so learned APP appears for the state of Assam. This criminal petition has been filed by the petitioner praying for quashing of an FIR which was lodged by the respondent number 2 with the Gitanagar police station, which culminated in Gitanagar PS case number 226 of 2020 under section 498A of oblique 325 of the IPC, and which was no charge sheet, nothing.
No, Your Lordship.
Huh?
No, Your Lordship.
No charge sheet. Okay, full stop. The learned counsel for the petitioner has submitted that the petitioner and the respondent number 2 were married at the time when the FIR was lodged by the respondent number 2, and the same was registered. However, during the entire period till when?
Till 39/2022,
Till
they have been
11/9/2025,
Lordship, 11.
the petitioner had no inkling about the lodging or registration of the FIR. Full stop.
Lordship.
The petitioner has, and the counsel for the petitioner has submitted that he has been selected for a government job, and when when a police verification of the antecedent of the petitioner had been sought for, it came to light that the said FIR was pending in the police station
Lordship.
for investigation. Full stop. The learned counsel for the petitioner has further submitted that the marital relationship between the petitioner and the respondent number 2 had been brought to a conclusion
Annexer 2, page 28.
by a decree of divorce
Yes, Your Lordship.
granted by the learned Principal Judge Family Court number 3, Kamrup Metro, Guwahati, by the order dated 39/2022,
Lordship.
passed in FC civil case number 1159 of 2022. In
Lordship.
such view of the matter, the learned counsel for the petitioner has submitted that unless the FIR unless the Gitanagar PS case number
226 of
226 of so-and-so is interfered with by this court, both the parties, that is the petitioner and the respondent number 2, would be put to suffer a litigation even when their marital relationship has come to an end, and further the existence of the aforesaid PS case would hamper in his quest for acquiring a government job. Full stop. The learned counsel for the respondent number 2 has submitted that the respondent number 2 would have no objection if this court interferes with the FIR with the Gitanagar PS case number so and so, since she now no longer wishes to pursue her grievances, if any, against the petitioner, since their marital life has come to an end. Full stop. Having heard the learned counsel for the petitioners and the respondent, and also having perused the records available before this court, this court, the learned APP has submitted that since the FIR had been lodged by the respondent number 2, and she now no longer desires to pursue the same, there is very little chance of conviction of the petitioner, even if the matter is charge sheeted. Full stop. Having heard the learned counsels and having duly considered the records before this court, this court is of the opinion that there would be no fruitful result if the Gitanagar police station case is allowed to proceed, since the informant does not want to proceed with the prosecution of the petitioner here in full stop. The apex court in the judgment of so and so has also held that in matrimonial matters, the court would be there would be no impediment in the way of the court to quash proceedings which may not lead to fruitful prosecution. Full stop. In view of all the above, this court is of the opinion that the Gitanagar PS case number so and so requires to be interfered with and is accordingly interfered with and is quashed. Full stop. The consequences of such quashing would be that there will be no pending criminal case against the petitioner in connection with the FIR dated
5/8/2020.
5/8/2020 lodged by the respondent number 2. Full stop. Criminal petition is disposed of.
Obliged much.
Finding item 14.
Next. Yes. Find out. We cannot pass an order without that. But let us also be this thing. And this court will be very loath to take up a proceeding suggested by you without an application, without giving him an opportunity to answer. Because otherwise, this court has to give him the notice that, look, we are about to do this. Why should we take the burden? Is it not? No, that is the affidavit. But the process that you wanted this court to take up for misleading or for even contempt or whatever, this court is not going to start the process suo motu. It is you who has to give us a petition or something which he would need to reply and then we can continue. That is one part of it. The other part of it, whether concentrating on the disposal of this petition will help you more rather than trying to drag him into all those disputes. The additional, the affidavit filed by the respondent number 2 is not found on record. Full stop. List this matter again by the sole respondent is not found on record. Full stop. List this matter again on the 23rd of April. Allowing the respondent to trace out and have the same tag with the records. If there are no other objections by the registry to the same, full stop. Interim order passed earlier to continue. Anything else? No.
Finding item 19.
Yes. Huh.
Mediation with the payment only. Already they have been divorced. Mediation, how will help?
The payment is to be made of what? Payment already divorced, but he'll still keep you paying you till the end of his life. No. Huh.
She has filed maintenance at Gauhati, and it has been judgment has been passed. And been maintenance that to the tune of rupees 7,000 for mother, 4,000 for child. Child is going to be is already admitted in school this year.
So we will say we will say that Mr. Sharma has today appeared and requested you to give the details to Mr. Sharma so that he can forward it to his client, who shall endeavor to make the payments as required by the orders passed in the interlocutory application. We will have the matter listed in April after the Bihu for consideration of the petition in case the payments are made. Otherwise, we dismiss it. If you don't listen to the court, if your client does not listen to the court, we have no option. I hate to order to do, huh? Mr. Sharma, learned counsel, appearing for the respondent, opposite party herein, has for the opposite party herein has submitted that in case his client is given the detail the bank details of the applicant oblique wife, erstwhile wife, of the applicant, comma, he would advise his client to make the payments as required by the earlier orders passed by this court in this interlocutory application. Full stop. Huh? No, we are saying earlier orders. What about the orders? Earlier orders passed by this court. Full stop. Mr. Sinha, learned counsel appearing for the applicant oblique respondent in the criminal revision petition has agreed to supply the details to the learned counsel appearing for the respondent for the opposite party herein oblique petitioner in the criminal revision petition. Full stop. It is provided that on being supplied the details, the learned counsel for the opposite party oblique petitioner in the criminal revision petition shall forward the same to his client, who shall make the payments as required under the earlier orders of this court. Full stop. It is made clear that the criminal revision petition would be taken up for consideration only after the orders passed in the interlocutory applications passed in the interlocutory application are complied with by the petitioner in the criminal revision petition. List again on 30th of April 2026.
Them 21.
It has. Yes.
You're telling the order dated from 12th of March before. Order passed by honorable you got to get the date for the initial order passed by also.
Which one? Item? Order dated?
Out of February 3 to 23.
You are under an interim order. You are under interim order. Trial court records have been received. Amicus is absent. What to do? We'll fix it on another date. This is matter again on 30th April in the hearing column. Since the trial court records have been, scan copy of the trial court records have been received, interim order passed earlier to continue. Learned counsel for the petitioner shall intimate the learned amicus regarding the next date of listing. There is an interim order.
Item 22 and 23.
We don't want to make two copies. Where is the I? I for what? What is that? Can we do that correction? No. What is the correction you want? Monday before the appropriate court. Yes? Yes? It is not sitting on Monday. No, but the correction of 23 is what? Monday. Huh? When a typographical correction to hold, it should have been Jorhat, it is written as Kamrup. We understand. It will not take 2 seconds to do it, but it has to go before the appropriate court. We do it this way. We reflect in the order that this is an order passed by another bench of this court. Therefore, register to verify and place accordingly. If it is placed before that court on Monday, it goes there. If it comes back to this court, we'll do it. Isn't it? Is it there today? Today is he sitting that court? লিখকচোন। The heard Mr. Jiuddin Learned Counsel appearing for the applicant, the applicant has submitted, the Learned Counsel has submitted that an interlocutory application has been filed for a minor correction in the order dated 7/1/2026, passed by another bench of this court, where a minor correction regarding the replacing the word Kamrup by the word Jorhat is required at paragraph 8 of the order. Full stop. It is noticed that since the order was passed by another bench of this court, the matter be sent back to the registry to verify if it is required to be placed before the appropriate bench and thereafter listed. Full stop. Learned Counsel for the petitioner has expressed urgency, and therefore the matter be listed on 23rd before the appropriate bench. It'll come up on 23rd. 23rd, you'll have an order, either which way. You produce it there, what to do? Tell the court that it has been corrected.
Supplementary for this section 55.
Eta matter, keta baki, sir. Just a minute. Criminal matter side baki ase. Tar pisot etu. That's what it says. We'll take up the criminal matter first. We'll take up the criminal matters first. We may need to pass some orders, then we'll dictate this order. Your criminal duty.
46 for orders.
Yes, madam, you were saying something in the morning? Hmm. 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 Okay. Now, madam, what has happened is this. Where is that order? ইয়াত কিবা হেৰি আছে নেকি? আহি আছে নেকি? নাই. Just a minute. Just a minute. You are appearing for respondent 4. Who is 3 and who is 4? Okay. And 4 is? Uh. But maybe at the time when you had eloped with her, that is the time when it has been alleged that he had also run away with her. Now, he cannot run away with 2 of them. Perhaps, I don't know. I have not read the brief. Otherwise, just a minute. Have you filed the additional affidavit, madam? You were required to file an additional affidavit. No. Sheet has been laid. You have to amend the criminal petition, or you have to file an additional affidavit. During the pendency of this petition, charge sheet has been filed. They wanted quashing of the FIR. So what is to be done now? So quashing of the FIR goes. No, why the quashing of the FIR will go? Charge sheet has been laid. FIR can still be quashed. All consequential process will go, but that has to be brought on record. Yes, madam. What is the process in a when a FIR is lodged? When a first information report is lodged by someone, what happens? The charge sheet has to be filed. Now, when you had prayed for quashing of the FIR, in the meantime, charge sheet has been filed. So what is to be done now? You have to tell the court by way of an affidavit that, sir, the charge sheet has been filed. So this is the charge sheet. Please quash the FIR so that the charge sheet can also get quashed. You have not done that part. Unless you do that part, there is no meaning for us to. That is number one. Number two, by order dated 192025, you were required to take fresh steps. Huh? That you have not submitted to the registry. So unless you take the steps in the registry, we cannot presume that notice is served. We cannot deem notice served. So what will you do now? File the additional affidavit and take fresh steps. Yes? Heard Ms. So-and-so and counsel appearing for the petitioner, also heard Mr. So-and-so and counsel appearing for the respondent number 4 and Mr. So-and-so and counsel learned APP for the state. The office note reflects that the amended petition or additional affidavit as required by the order dated 192025 have not been received by the registry, full stop. Further, the fresh steps required to be taken by the same order have also not been received by the registry, full stop. The order dated 192025 reads as follows. Okay? Learned counsel for the petitioner to verify and take appropriate steps as required by the order dated 192025 within a period of 15 days from 10 days from today. List the matter again on 24th of April. Full stop. And if the charge sheet has been filed, then you will also require to file a IA for stay of the proceedings in the lower court or in the trial court. Yes.
49.
14, huh? Oh, finish koi na patakke. Yes. Huh. Huh. Now, unless what is the allegation? What is the allegation? Today? No, petitioner is not here because it is 1-5. What is the matter? DV Act, okay. Maintenance has not been paid till now. We'll take it up on the 7th of April. List again on the 7th of April. The learned counsel for the Mr. MSA, learned counsel for the respondent has submitted that the petitioner has not paid the maintenance amount till date. We said list on 7th of April. 7 April. Sir, after some refreshment, we'd like to take up this matter. At 2. I think the matter was already decided upon. We just need to dictate the order today. We'll do that at 2. Ask him. The date of your retirement? 22. 3 years, okay. And
One thing, my lord, page number 23, and please,
no.
page number 23. Very good. Serial number 3, my lord. Yeah. Page number 23. Then the previous one,
No, you would have to look at page number, serial number 2 first. Is it? So in the year 2010, it is only in the year 2010 that, and she does not make any contribution. It is you who deduct it and send it to the NPS fund. A person who is already getting money deducted in the GPF, why would a sudden jump come up to NPS? Because 30 November 2025, that goes post the date of NPS, is it not? 1/1/2000. What was it? 1/1/2005. So 1/1, this order came on 30 November 2005. Someone got smart. It should not happen. Now all those proceedings are somewhere in your files which now you are trying to trace out. Is it not? So what you are now trying to trace out? In that view of the matter, whether she was given that notice, whether she had a signature, now that you have taken up this question, whether she had signed the NPS form at all, or was it simply converted? Because if it is started from 2010, what happens to the period from 2005 to 10? 2005 she got that regularization. From 5 to 10, what did she do? Why this sudden change from 2010 onwards? So from 5 also she continued on the GPF till 2010. Serial number 2 at page 23. And if she has already retired in 2022, survival is 52,000. That 52,000 withdrawn in March 2024 has to be survival. Technically, we can look at it in many ways and make a big mess out of it. But practically, what is the situation? 2004 onwards? No, I think 2008 onwards to 2010, the GPF was there. She has a GPF account number. And then you say her service was regularized by letter dated 12/12/2006. We don't find any letter dated 12/12/2006. Or maybe after this page 16, the 12/12/006 came out. Just stating that she stands regularized. But the governor has given the regularization with retrospective effect. That will be from the date of that is what they have joined. The governors, this thing cannot be. Achha, let us see one more thing. Your letter, reference your letter. Dated sensitive. You have taken the instruction from whom? Government.
oh, this letter is from my lord, page 16.
Hmm.
It's from Judge Wilson.
Yes, it has to
I
come.
can take it from the backside.
But then the director would have a copy. It is addressed to the director.
Yes, but madam, the thing is, how this government has not issued this letter, madam. So that
Okay, then we do it this way. Since they have prayed for the time to try and trace out that order, we'll keep it. As part heard, we can keep it till 12/4. 12/4 being a holiday, we can take it up on the 21st of April. Immediately after the vacation. You try to find out. Ha. Ha. But tentatively, our view remains. And you can also have, we'll not record it in the order. You can also have an instruction as to whether that particular person with whom she was regularized. At page 16, this Sanatan Bhakot. Allegedly, he is drawing his. Huh? They are not, they are. Huh. Hmm. That reply has not been of Sanatan Bhakot. Hmm. This is what? Page 39 is what? Acha. NPS scheme. Mr. Chakraborty, you are appearing for the AG. So if they send you the papers, you have got. Hmm. Yes, sir. We'll have to give them that opportunity to find out that letter. I was ready to dispose it of, but this prayer has made it difficult for me. If I don't give it, they would have an appeal, saying that we are not even given opportunity. Yes, the matter had been heard, Mr. U.C. Raval under counsel, appearing for the petition, also Mr. Ardhol, an additional senior government advocate, and Mr. B. Chakraborty, under counsel, appearing for respondent number 6. By the order dated 12/2026, the additional senior government advocate was required to obtain instructions regarding a order dated 30/11/2005. Full stop. The 2005. Full stop. Today, the learned additional advocate general has submitted that the file is being traced out and would require 3 weeks time. Full stop. Accordingly, list this matter again on 21st of April for further hearing.